another year the opportunity. This panel is going to be certainly co-moderated by my esteemed colleague, Dr. Maria de Longoria from the History Department. And yes, indeed, I know that there are going to be a lot of questions in terms of the American judicial system and of course, on the British system. You have solicitors, you have a number of different ways of how you work. I want to thank you and thank the enrolled and my colleagues for seeing it fit to bring this concept into this program of the International Business Conference, Dr. Data. Moreover, what we're looking to do to establish is to bring forth both the social and historical side here, on the other side, how our justice system work, and then also to the history of it, which is why Dr. De Longoria is on here on board as well. We know that the law is applicable, certainly in business, as this is a business conference. And what we'll hear from is judges on the Civil Court of New York, which was established in 1962. The Civil Court, by the way, is one of the busiest, okay? I repeat, the busiest court of civil jurisdiction in the United States, right? The court has jurisdiction over numerous actions, including contracts, as we talk here about building, personal injury, real property. And right now, currently, you know, we know that there's a limit right now in cases that you hear that comes up to claims of a maximum of 25,000. But also too, we have one of our justices, Deena Douglas, who we'll hear from later on, and she sits on the criminal side of the Supreme Court. So while, you know, the intersectionality of both, we're hoping to present and give you the history of that. But we know the Supreme Court was established and formed together in 1846. So if you're looking at the history of this, and then there's also on the civil side, we have the housing part component that was formed in 1972. So I'm not going to waste much time. You're going to hear from them. I'm going to ask each of them briefly to introduce themselves using a minute or so. You have their bios, and then I'll turn it over to Dr. Maria de Longoria. I'll start first from what I'm seeing on the camera, and I have first Judge Dweynie Mr. Paul. Dr. Paul, introduce yourself to the members here. We have people from Pakistan, India, Germany, Israel, all over the world. So the show is on to you now.
Hello, everyone. I can say good morning, good afternoon, good evening, no matter where you are viewing and joining in with us. Thank you so much for the invitation. My name is Judge Dweynie Paul, and I am currently a Kings County Civil Court judge, which is Brooklyn, New York. I started in 2016. My election was in 2015. And I started in family court. And from family court, I came over to civil court, and I'm here presiding over various cases. We have consumer debt, any matters under actually $50,000. We just had a recent election, and the election increased the threshold for civil suits that are filed here. And so any case that is valued under $50,000 comes to our court. That also includes some commercial landlord-tenant cases. I'm looking forward to talking to you more about it.
Great, thank you so much. And now I turn to Judge Honorable Heela Capell.
Hi, good afternoon, everyone. I'm so honored to be here with all of you, with my esteemed colleagues who I admire so much. And I'm a lifelong New Yorker. I was born to parents who are both from Israel. English was my second language, actually. So to all my international folks, hello. I was appointed to the Housing Court Bench, which is a citywide appointment in 2018, and I took the bench right away in Manhattan. I was transferred over to Brooklyn right before the pandemic in February of 2020, doing housing trials here for the past 2 years. And then at the end of last year, I was elected to the Civil Court, which is just Brooklyn only. And I am currently sitting with Judge Paul in Brooklyn Civil Court. And I look forward to addressing all of you. Thank you.
Great, thank you so much. And next to our other judge who's on the civil court, Honorable Patria Frias-Colon. Colon, I see you have the accent on. I told the folks in London they just couldn't get that accent on the O, but we can see it on there. It's all yours.
Greetings, everyone. Like Mr. Mayers indicated, my name is Judge Patria Frias-Colon. I'm currently the supervising judge here in Queens County Civil Court in New York City. I look forward to continuing to hear from everyone and to answer the questions that are being posed. And I'm really excited about being here. Thank you for the invitation. Thank you again, Mr. Mayers and Dr. Gloria.
Indeed, indeed. And welcome aboard, of course. It's a pleasure. Now we're going out to Honorable Dena Douglas. Dena Douglas is a justice. She sits on the Supreme Court. Now, you just heard from the judges on the civil court. Now, Judge Douglas will tell you a little bit about her rise and a little bit about the Supreme Court.
Thank you, Professor Maris, Professor De Longoria, and distinguished guests. Good afternoon. Or good evening. My name is Judge Dena Douglas, and I do serve in the Supreme Court in the criminal term. I've been a judge since 2007, so 16 years. I like to say I'm the baby of the bunch. It's an honor to serve the county where I was born and raised. I'm a daughter of immigrants from Grenada, West Indies. And in the Supreme Court, there are two branches in New York State, which is the civil term and the criminal term, where I sit, and I handle major high-profile criminal matters, including homicides, sexual assaults, and other major violent crimes. Well, what I like to say is, before joining the bench, I was a federal prosecutor, prosecuting matters of international and domestic terrorism. The intersectionality of the business matter, white collar, and the criminal sphere are all relevant to our discussion today.
Great, thank you, Justice Douglas. And now I'll turn it over to my colleague, Maria de Longoria, who's going to put some historical context to this and the historical nature of it, that we would really see the highlights of why we label, well, the label is really, you know, the business of the bench. It is a business, and we're going to get into that business part of it as well. Maria?
Sorry about that. Hi, good afternoon, good morning, good evening. As Professor Mayer shared, we'll be discussing the impact that women jurists have in their courts and on the system. And although we're making progress, as witnessed by our illustrious panel of women jurists here who briefly introduced themselves, and you're going to love what they have to say, it has to be noted that the overall judiciary does not adequately reflect the population that it serves, which draws into its legitimacy into question, and also creates consequences for those who come before it. This has been a long-standing issue, even though the first woman was appointed to a judicial position in the 19th century. In 1870, Esther May Hobart McQuigg Slack Morris, that's a name, isn't it? She became the first woman judge in the country. She was appointed as Justice of the Peace in a small town in Wyoming. Now, this appointment came in the wake of Wyoming passing a bill giving women the right to vote and to hold public office at a time when most of the country prohibited such. We have to keep in mind, for those of you who are not that familiar with US history, the 19th Amendment, which was an amendment to the US Constitution and granted women the right to vote, was not passed until 1919. So Slacks Morris was in 1817. Wyoming had already given women the right to vote. And it wasn't until 1919 that women in this country gained that right nationally. Now, Wyoming is not that Wyoming was a progressive territory. They were attempting to attract more women to settle in the area. The governor appointed her to fill the position when the man who previously held it stepped down in protest of the voting rights. And it's important to note that not only did this previous justice oppose her appointment, but so did her husband. It took about another 50 years before another woman was appointed in this country. Now, I am not making a distinction between courts for this part of the discussion. We're talking about overall. Florence Ellenwood Allen is the first woman elected to a state Supreme Court. She was elected in Ohio in 1922. Later, she became the first woman appointed to the United States Courts of Appeals in 1934 by then President Franklin Delano Roosevelt. So you see, we started in 1870, and then now we are up until 1922 before we see another woman. In 1939, the nation saw its first Black woman judge, Jane Matilda Boland. Boland was the first Black woman to graduate from Yale's Law School. She was the first Black woman admitted to the New York State Bar, and she was appointed to New York's Domestic Relations Court in 1939 by then New York City Mayor LaGuardia. Now, those three women that I highlighted were all appointed to different types of judgeships and had very different experiences getting there. I think Professor Myers is going to now talk to you a little bit about the structure of the New York and US Judiciary.
Well, thank you so much. At this point, what I would like to do, I would like to let the judges then talk about that. And I think Judge Douglas talked about it briefly. So if I have Judge Douglas to just say a little bit more about the structure of the Supreme Court. I know you mentioned early the civil part and the criminal part, and then have Judge Patria Frias-Colon just say a little bit more on the civil side again. And thank you, because we have folks from internationally all over. If you just share a little bit about that, I would rather it coming from your mouth rather than mine. I'm an attorney, but I want to hear it from your mouth.
My pleasure.
Sure.
So to discuss a bit more about the Supreme Court here in New York, the Supreme Court is the highest trial court in the state of New York. In other states, the Supreme Court is the highest appellate court in the state. So New York flips it a little bit, but it is, again, after you reach the Supreme Court in New York State, then you go to the appellate court. So there are no other trial courts that are higher than the Supreme Court in New York State. And again, we're divided into two branches, civil and criminal. For those who may not be well-versed on the distinction, criminal are crimes and civil is everything else. That's the best way to look at the distinction. There is, again, a monetary threshold to get into the civil court on the supreme level. It also is a matter of the nature of the claims that come into that court, the types of injuries, the types of medical malpractice, divorce litigations. And again, I'm coming back to the Supreme Court criminal term, which is my wheelhouse. There is a lower criminal court that hires lower offenses, but once a crime, which is dictated by the laws of New York State, our statutes. If a crime falls under those parameters and you're exposed to a year or more of jail, then your case is heard in the criminal term in the Supreme Court. And although the threshold is a year or more by statute, I've done sentences upwards of 40, 50 years after a conviction of trial for the crime. So I think I'll pause there after giving a broad stroke discussion of the Supreme Court, and then we can delve into it a bit more when time permits.
Great, thank you. Judge Colon, on the civil side, to add a little bit more.
Yeah, thank you so much. So on the civil side, we're a court of general civil matters, and specifically in New York City, the civil court is it consists of three different parts. You have your general civil matters, which now, as Judge Dweeny Paul indicated, we have jurisdiction over any lawsuits involving $50,000 or less. Then there's also a housing component where we have judges from the housing court, and they handle all the residential housing matters where landlords need to evict tenants or where tenants need intervention from the courts for various reasons. So we have a housing component. Then we also have a small claims component, which means that there are cases that are $5,000 or less, lawsuits between two people, and so the small claims matters will be addressed that way. New York City, for example, being the court of general jurisdiction, when you have matters of $50,000 or less, they will come to the civil court. And in that civil court, it can be anything. It can be a commercial issue that's $50,000 or less. It can be a lawsuit involving a car accident. It can be an insurance carrier suing another insurance carrier to get reimbursement of money, subrogation cases. So there are just so many, it's infinite, the level of, or rather the number of conflicts that people have. And as long as those conflicts are under $50,000, they will be addressed in the civil court, which is a court of general jurisdiction. Also, I would like to say that specifically with, for example, landlord-tenant matters, instead of commercial tenant cases or landlord-tenant cases, those are immediately heard by the civil court judges instead of it going to housing court. But there's just two more things that we do is the name changes. There are often people that want to change their names, and those go directly to the civil court for whatever reason. There are so many different reasons that people want to change their names, and so they initiate a petition in the civil court, and the judges get to hear the reasons and determine whether they are acceptable reasons for someone to change their name. So I'll leave it there, Professor Mayers, and then we'll hear from others.
No, thank you for that and putting that in context. I think it was helpful, again, given the broad faculty and staff members that we have internationally. I think I'll turn it over now back to my colleague to go delve a little bit deeper, and then I'm going to come back and we're going to talk.
This meeting is being recorded.
We're going to come back and talk a little bit more on some of the, we've set it up with just 5 really intersections questions. So it will be really deep in the meat of it, and it wouldn't be a boring session for you, promise you. Dr. De Longoria?
Hi, before we get started, I'd like to ask Mr. Gabriel Samuel, if you would mute your phone, please. We're getting some background noise.
Yes, thank you.
From that particular participant. Okay, so let's get into our questioning. So one of the things that I think is interesting is that there are paths to becoming judges, right? And sometimes those can be traditional paths, but I think for women, they're varied. Perhaps even more than for some other folks. So the first question for the panel is, what are main paths of women judges to the bench? And who would like to address the question first? Maybe Honorable Capel, since we haven't really heard from you yet.
Sure. So I would say, I mean, there's various paths to the bench for everyone in New York State. So I don't know if I could say maybe a little bit about that to put it into context, which is that, well, for example, when I became a housing judge, that was a nomination process. But when I became a civil court judge, that was an election process. So just vaguely, I guess, there are different paths in general. As a woman, I guess a little background on myself would maybe give some context, which is that I was raised in a very Orthodox Jewish neighborhood where I went to Jewish school for the better part of my life. And there was a large value placed on becoming a wife, having children, etc. And so I would say for myself, finding my own value in a different sphere as a woman was required before I decided that aspiring to the bench was something that I wanted to do. And I could see that being the case for other women, which is that you have to place your own value sometimes as a woman on your career, or at least that was the case for me. And that really pushed me forward to the path to the bench.
Okay, thank you. How about, we also haven't heard too much yet from Honorable Paul.
Hello, everyone. So I'll tell you, I don't know necessarily the statistics as to whether the majority of women on the bench are appointed in the state of New York or elected. In our courts, as Judge Capell mentioned, it's typically 2 pathways: it's appointment or election. I know that there are a lot of challenges as a woman to run a judicial campaign, because like a judicial campaign, in large part is very similar to any traditional campaign for a traditional elected official, a legislator, governor, mayor, president. The process is typically the same. There are different restrictions that as judicial candidates that we have, but for the most part, the process is the same. You go out into the community, you try to garner support either through the community to go out and vote on election day, or elected officials who might give you endorsements, or community leaders that might give you endorsements. And some of the challenges for women to become elected as opposed to being appointed is that there's a lot of financial resources that may come into play. I think a lot of women, sometimes we play such an active role in home, being a caregiver, either to our own children, to our own partners, or sometimes being a caregiver to our parents. And that poses complications for female candidates who want to run because it is extremely, extremely time consuming. So it really becomes a family affair. Everyone in the family has to be on board to run the campaign and balance as best as you can that work-life challenge. So those are some of the things. I think sometimes there are some nature of a woman that might be, that adds to the process of a campaign, and I think becomes our asset, and sometimes might be something we have to work on, because a lot of times it really requires going out and being outspoken into the community. But that becomes our strong suit because we are very compassionate. We understand, because we play such a pivotal role oftentimes in our household and in our community, that helps to support a judicial candidate, because the work that we do as community organizers sometimes and helping out in our local organizations helps to support that role when we're running for a judicial seat.
Okay, thank you. Judge Colon, would you like to add anything?
Yeah, I mean, for me, just to add to everything that's already been said, there's also the component, for me, I was the first Dominican ever elected in the borough of Brooklyn. And so when you have that sort of immigrant background, that also poses another layer of challenges in our communities. But I agree with everything. You know, it's from a woman's point of view, as sometimes being so actively involved with your families, our children, if we're married, or our partners, it definitely adds another layer. And so you need a lot of support, not only from your family, but also from the community, to be able to have a successful campaign. I was elected to the civil court bench. I also had the opportunity to try and be appointed in New York City. Specifically, those are the methods. You can either be appointed by the mayor of the city of New York, who can appoint you to the family court, and the mayor can also appoint you to the criminal court. The mayor can also do interim civil court appointments for up to 1 year. The other way in New York City is that the governor may take interest in you, and you can be an attorney and be appointed by the governor to the Court of Claims, where you can either sit to hear state matters, or you can be assigned to the to the Supreme Court, where Judge Douglas currently sits in the criminal term. And so there are just so many different ways that this can happen, and we all have such different journeys, and each of our journeys is different. Even if we all decide, let's say, be elected, even that journey is different for each of us, given our backgrounds and given what we've brought to the table into our communities. But thank you for that question, Professor Deana.
Thank you. And Roxanne, may I just ask Delaware to have Ms. Roxanne Foster to turn her camera off?
I just sent a message.
Okay, thank you.
I don't know.
Continue, Dr. De Longoria.
Right. I don't know if Ms. Foster sees it, but obviously,
Can I add just
not.
one piece?
Yeah, sure. Go ahead.
You were next.
I wanted to, something that my colleague said sort of sparked a thought within me as a woman on the bench, and part of it is having a partner not having a partner, running as a single candidate, or running as somebody with a partner. And those is an interesting dynamic that we have to face that I'm not sure our male counterparts have to encounter. And in my entire career, my entire 16 years, I've been an elected candidate. I ran 3 successful campaigns, didn't lose a single campaign. And in my first campaign, I had a partner, I was married, and then my husband passed away. So then my next 2 campaigns, I ran as a single working mom. And the challenge of that was a different dynamic to see the response or the interaction that you may have from either the community, those you're seeking the support of, just the entire process as a single candidate can be different, was different for me than if I had a partner by my side. And I think that's a bit of what some of my colleagues were speaking about. And it can be a challenge that unless you've going through it, you may not really appreciate as a woman candidate. And even not that it's harder when you're single than when you have a partner, because even when you have a partner, there are challenges there where you may or may not be recognized fully for who you are and what you bring to the bench as the candidate. So it is an interesting dynamic and quandary that we face that I'm certainly hopeful in my daughter's generation that we won't be having this conversation.
Right. Thank you, Judge Douglas. And that kind of brings us, flows nicely into our next question, right? So we kind of talked about the paths for women, but what about the gendered experiences for women when you're on the bench, right? That is a whole nother dynamic. And so since we ended with you, Judge Douglas, we'll start with you. We'll kind of reverse.
I love that also. So I have the pleasure of having experience, and I like to say the appearance of youth on my side. So when I first took the bench and I would walk into the courtroom, because people didn't know that I was the judge. So I might walk in and not necessarily with my robe on. You don't have to enter the courtroom with your robe on. So I might come in, set up, start, and I think people thought I was there to set up for the judge. And then I would turn or maybe step out and come back in with my robe on. And there would be at times audible gasps that I was the judge. And and even to this day, when I walk into the courtroom, there could still be a surprise that, well, this is the judge. And that is, and I don't think that that's going to go away, at least again, through the time that I am going to be on the bench. I hope it does. I feel as though through the course of my career, it has diminished. But it's something that throughout your career you are aware of as a woman on the bench, and we're all immigrants or daughters of immigrants, and are therefore bring that experience to us on the bench as well. So we're used to having to fight harder, and it may sound a bit of a cliche, but it's just absolutely the reality. We're used to having to fight harder, be more experienced, be more qualified, be overly prepared, because the expectation is that we may not be able, the bar for us may be lower, so we rise higher.
Mm-hmm. Thank you. I'm going to like to remind people to please mute if you're not on the panel. Thank you very much. So I'd like to ask Justice Colon, would you like to comment on that question?
Yeah, I could not agree more with my colleague, Justice Douglas. I have to say, often, before I even became a judge, walking into, I used to be a prosecutor in Kings County, and I'll share a very brief story with you. 2 things would happen to me. One is people could not get used to me entering the building as an employee. of the building, right? So I would get ID before any of my colleagues would get ID. So that was one issue. And then the other issue was when I was, as a prosecutor, getting ready to prepare for my cases, looking through the files, I have been confused as a defendant because they just could not, it's almost like a disassociation effect or impact that it has on someone seeing what I'm supposed to be doing, going through my files as a prosecutor, and then them thinking that I'm not. And so I have been almost asked to sit where defendants are supposed to sit. So that's the general experience, and that wasn't really so long ago. Fast forward to me now being a judge, especially I've been a judge in the family court. I've now been a judge obviously in the civil court. And so both courts having such different jurisdictions and different people that come before the court, I have had to remind counsel to address me appropriately, because sometimes they don't address me the way they would address, let's say, for example, my white counterparts. I've had to be very specific in my comments on the bench, because sometimes there are challenges. Sometimes people feel they can challenge someone that they're not used to appearing before. And so those are the different things that I've had to remind people who come before me, including litigants, not just the attorneys, but sometimes I think litigants are very surprised. The nice thing about me being on the bench is that I have seen people come into the courtroom and almost have a sigh of relief when they see someone that looks like me on the bench. So that's the other beautiful part about being a woman of color, being a Dominican on the bench, right? A Spanish speaking person on the bench. And I've done things like speak to people in Spanish, where I have a court interpreter, and I'll have the interpreter interpret in English so that everyone can understand, because sometimes you need to speak to people in their tongue to try and help them to understand the significance. And so often I wish I knew so many more languages, because I do really find that it's so much more effective. But I find that my physical appearance has brought ease to people when they come before us. And I always am so happy and am careful to make sure that I'm courteous, that I'm patient, to be as efficient as possible for the task that's before us that day, right? And so I keep all of those things in mind as an immigrant, as a mother, a second generation from the Dominican Republic, as a person of color from an inner city community. And all those experiences have really helped me become the best judge that I think I can be.
Okay, thank you. I want to give Justice Paul and Justice Capell this next question, but it's one that you can also include any gendered experiences of women in your response, right? So this question is, does having women or more women on the bench impact judicial outcomes? If so, in what ways? And it may differ by court, and you can include that if you want in your response. So we go ahead and start with Justice Paul.
Thank you. So that is a very important question. I will say initially, first I join in with Justice Douglas and Judge Colon's response about, that experience, what it's like to be a woman on the bench. And I think we all bring our whole selves to the experience of becoming a judge and presiding over cases. But initially, our role is to be impartial and not to be biased. And while you cannot separate who you are to any work that you do, our role initially is to look at the law, look at the case law, look at the legislation, what was the original intent of it, and administer justice. But there is a place for discretion and real understanding. So you want to come from a place where you understand the people who appear before you. So if you're in criminal court, civil court, family court, if you're in Supreme Court, you really have to understand the people who are coming before you. And I think that's where it might play a role. So my family is from Haiti. I'm also, I'm a first generation immigrant to live here in the United States. And I think being a woman plays some role of understanding. And I think it becomes an asset because I started in family court, and I think it gives me an opportunity to really help the parties come to a meaningful resolution. And even if they can't settle the case, if I can't speak to the parties from a perspective, relate to the mother who might be coming to court, and also relate to the father who's coming to court, remind them of their common interest and their common goal of having this child thrive in life. Bringing that experience to it really helps me to allow the parties to come to their own settlement and resolution. And if not that, at least narrow the issues so that if it comes to a point where I have to do a trial and make a decision, even in the way that I write the decision, it's in a way to make the parties understand that they were heard, that I understood the circumstances that brought them to court, brought them to the day where the court had to make an important decision over their lives. So I think that all those come into play in being able to service litigants better. In civil court, I often say a lot of times it's the same population. So there are litigants that I've actually had in family court, and I've seen them in civil court, because you're talking about a dynamic and a dimension, a demographic of people who are in need of the court. We call civil court oftentimes in New York, the people's court. It's where you go to deal with day-to-day issues of neighbors, of small business owners who have disputes. And now with the pandemic, we dealt a lot with the commercial landlord tenants who were small business owners, mom and pop shops that were struggling during the pandemic, and landlords who were trying to figure out, how do I keep the mortgage paid if the commercial tenant is not paying the rent? So I think coming from a background of being someone in the community who's living a day-to-day life, being a woman who understands the challenges and balancing the different roles, I think I was able to bring some of that wisdom, understanding to a case and further the best resolution as possible.
Okay, thank you. Before Justice Capel answers this question, this is our 3rd out of 5 questions. Just to keep everybody on point on where we are with time. And we were going to allow a brief period for Q&A, because we have been getting questions in the chat directed to either Professor Mayers or myself that we would like to bring to the audience. So go ahead, Justice Capel.
Thank you. And I'll try to keep it brief because I'm sure people want to ask questions, and I feel like my colleagues did such a good job. Something that I can add is also, I'm going to use that appearance of youth that Justice Douglas said. And, I had the same thing happen where I would walk into a courtroom and people would ask me, oh, I want to speak to the judge with all due respect. I don't want to speak to the clerk or whoever they assumed that I was when I was trying to just get in there and conference a case real quick. People have felt very comfortable telling me what they thought of the way I look. People will tell me that they think, this way or that way about how I look. People will tell me how old they think I am. They'll comment on my age. And I have to say that depending on who it is, I don't always, I won't scold people necessarily because, especially when I was in housing court, I felt that if they felt a level of comfort and it wasn't coming from a place where they were being disrespectful, but rather they were coming from a place where they were nervous and wanted to connect, and they saw me as someone they could connect with, as long as they were treating me with respect, albeit it's not a respectful statement. Mm-hmm. I think that I took it, and maybe this is from being a woman. I don't want to say anything against men, but I think as a woman, I didn't have that sort of pride thing where I felt like I had to correct or admonish, and rather I said, okay, now let's move on, and let's talk about your case. I also, when I became a judge at first, my daughter was 3 and my son was 5. And in housing court in New York City, especially, you're dealing with people who don't have attorneys a lot, with tenants who don't have attorneys in particular. especially in Manhattan, and the other side is usually represented by counsel. So a lot of unrepresented litigants would come in with their children because either they didn't have childcare, or they have young kids, or they couldn't get them to school that day because they were choosing between taking them to school or coming to court and making it in. And for me, a noise does not bother me. I came from a household where it was a little bit wild all the time. And so I was okay. And I feel like people were so nervous about bringing their kids in, and I would always tell them, please, it's fine. I don't mind any noise. I don't hear it. I just hear your case right now. I'm totally comfortable with that. So obviously, as a mom, I think that's something that I brought in. Also, real quick, dealing with unrepresented litigants as a woman, as a mother, and understanding what they were going through, the pressures that they had as family members, trying to make sure that their family was taken care of. A lot of people felt ashamed that they weren't supplying them with an essential need, which is a home or a house. And I would try and sit with them for as long as I could and talk them through whatever issue it was. So as Judge Paul said, obviously you're applying the law to the facts, you have to be impartial, but that does not mean that you don't have to be a human. And that does not mean that bringing in your own humanity, connecting with the people that appear in front of you, is doing a disservice to your case. It's actually helping your case. I think that helps foster justice.
Okay, thank you so much for that. That added so much to the conversation. At this point, I am going to pass the questioning over or back to Professor Mayers.
Sure, thank you so much. I'm going to bend a little bit more to the business, as this is the International Business Conference. And what I would like to do is really ask, the pandemic has left folks in all disarray, business as well. I know small businesses. Earlier, we had a panel with Michael, Professor Michael talked about the business, and Professor Byron also talked a lot about how the business aspect works. Tomorrow, we're going to talk more about the trade centers and how that impacts post-pandemic. What I really want to ask now and focus with, I know bankruptcy, a lot of folks who file for bankruptcy. Bankruptcy is done in the federal court, in the federal bankruptcy court. But I know, in fact, from some of my small business owners who are mechanics who have not been paid for services being rendered, and they're bringing the matters up into court in Queens and in Manhattan. I know on the landlord-tenant side, of course, we know we had a moratorium with landlords and owners are saying, I have not been paid. We know they're on the commercial side as well, and this is New York City. This is next to London, very commercial city where a number of transactions are done even on the internet, and we're seeing a lot of conflict. One, can you talk a little bit more on the commercial side in terms of some of those cases, one, that you've come before you? And number two, how then do you deal with applying the law to the facts in matters like that, given the time that we're in with the pandemic? Owners cannot come up with a payment, manufacturers may have sent something out, and there's these suits back and forth. So if you could just elaborate on that, what are some of those business on the commercial side, consumer debt sides that come before you, and how are those kind of settled? How do you rule in cases like that? I'm sure my business colleagues here in the schools of business all around would like to hear a little bit about that. Any one of the judges.
So I can certainly address that, as
Sure.
Myself, Judge Capel, and Judge Paul, we're all on the civil court bench currently. And anything above $50,000 would go over to the civil term of the Supreme Court. But to the latter part of your inquiry, which is how do judges deal with deciding cases where both parties are struggling, right? And when we look at the commercial landlord-tenant, for example, this is where usually a landlord is bringing a case to evict a commercial tenant that hasn't paid rent for a long time. And for those who are not aware, in New York State, and to some extent at the federal level, there was a moratorium that precluded cases from going forward during this pandemic, which lasted over 2 years. And we're still working through this pandemic and how we get back to full operations, which we have been soon after the pandemic. But what I do as a judge is I am very specific about what the status of the law is before me at that moment. And then I look at the contracts between the parties, right? And then I always ask the parties, is there any way this case can be resolved? Whether it's an issue of rental arrears, whether it's an issue between neighbors, whether it's an issue between two parties having engaged in a contract of any sort, whether it's for products, whether it is for services, whatever it is, I always encourage the parties to try and resolve the case, because I say to them all the time, this is what I do all day, every day. I don't have a problem taking this to a hearing. I don't have a problem taking this to trial and making a decision on the facts. But at the end of the day, I say, are you going to trust a stranger, myself, to sort of impose upon you a decision that might not fare off as well for the two of you or whoever the parties are? And oftentimes that helps bring resolution. And I also like to speak to both parties privately, which you can do in civil court, which is a wonderful thing that the judges can do. And I try to really get to the bottom of what really is driving this case. What's really driving this person to either bring this lawsuit, or what is really driving this person to resolve this lawsuit? And at the end of the day, when you really get down to it, and I take the time to be able to do that, you find out that things are very resolvable. Now, when things are not resolvable, yes, I look at the law, I look at the facts, and to Judge Paul's point earlier, there's always that area of discretion that judges have. And I do bring my experience in all kinds of different areas of the law to bear and to guide me with that discretion.
Got it. Thank you. Anyone else to add?
I can add a little bit to what Judge Frias-Colon just said, which is that absolutely, especially during the pandemic, at a time when people feel on both sides that so many systems have failed them, that, you know, nature has failed them, the world has failed them, socially people are isolated. I think that the coming back into court, which is what we've been seeing over the past few months, has resulted in so much trepidation that my main goal is to stop the bleeding as much as I can. And the way to stop the bleeding is to really, I try to approach it from the most human side, which is that we're all suffering right now. Okay, we were suffering before, but now it's worse. And so now you're here. And how do I help you? Help me help you right now. And yeah, maybe at this point you're at odds with the other side because it's been so long that this dispute has been going on. But I try to make people see that the best way to really go about this at this point is to hear what the other side wants and see if they can live with it. And also to really understand what they themselves want and what's going to serve them the best to move forward and through this pandemic. That's all I wanted to add.
Great. No, very well. I'm glad you add that to it. And the last question now before Q&A, because I know we have students, we have panel members of this audience who have questions. I wanted to direct this, so thank you both, judges, Capell and Colon, Judge Dena Douglas, Justice. We've got a number of inquiries and questions from here across the Atlantic, folks who were watching in Africa. We have folks from Africa on here, the nomination process, the confirmation hearing of Judge Ketanji Brown. Could you tell us on a lot of the questions, including a number of our students here at Medgar, we teach the Business Law 1 and 2, which is UCC, Article 9, we do as well. And we also teach criminal law, criminal procedure as well. And they do cover sentencing. Could you tell us, the students and the audience, of why she was peppered so much? So explain the sentencing guidelines, what judges have in terms of their discretion and how far you can go out of that. Because she was criticized, and a lot of folks from our communities just didn't understand how what you work with as justices of the Supreme Court, or even on the civil in your decision making. Could you add to that for the audience, Judge Douglas?
Sure, of course, my pleasure. There certainly was a lot to unpack from the confirmation hearings of Judge Ketanji Brown Jackson. And it cannot be lost on anyone that the either conscious or unconscious biases came into play throughout the scope of the hearings on many fronts. This is the first Black woman to come before the Senate Judiciary Committee for confirmation to be a Supreme Court justice, which is a lifelong appointment and could shape the laws throughout the United States. She's a young woman and will have many, many years to serve on the bench. While her nomination and appointment to the bench was not going to necessarily shift the tone of the bench, because currently the bench is skewed with a heavy Republican appointees, and the Judge Jackson was appointed by a Democratic president. So her appointment was not going to shift that power. There's the fact that there was one additional appointee coming for one side certainly made the other side question and concerned and ask questions that were really outside of the realm of what a nomination process could be. When you compared some of the questions and inquiries to Judge Ketanji Brown Jackson to some of the immediate predecessors, especially though the two before her, it was certainly night and day. But I do want to drill down a bit on the issue of the sentencing, which ultimately sentencing is a fair question to ask a jurist to understand what the process is, how they arrive at their sentencing decisions. You want a judge to be fair, balanced, learned, thoughtful, compassionate, caring, intelligent, and throughout their entire career on the bench and their evaluation of the cases. However, the focus for and the attempt to portray her as being an extremely lenient sentencer was unfair and was without merit. Because if you are sentencing hundreds of cases and you just take two in an isolated prism, and two that you want to show or paint a picture in one way. I mean, listen, we can move mountains for things that we want to do, or we don't have time to do the things that we don't want to do. So you can always create a dynamic and market it for one way or the other. And coming in, a bit more in focus about sentencing in general is there is a range. And the range is not decided arbitrarily by the judge. The legislators, one of the branches of our government, they are the ones that create what guidelines the judge has to follow. And certainly there is a minimum within that range, and there is a maximum within the range, but these aren't arbitrary numbers that the judge arrives at. And also in looking at your sentences, the sentence you choose to impose upon the case, you take into account a number of different factors. Certainly it's if it was a jury trial, the jury has spoken, you look to what the charges the jury has convicted the individual on. You take into account a sentencing letter that the prosecution would present with other supporting documents. And similarly, you would look at a sentencing profile submitted by the defense with other supporting documents who can come from anyone, community members, it could come from family members, it could come from religious organizations, and that's for both sides. So you're taking all of that into consideration.
Thank you. Okay, excellent. Well said. I know Dr. Datta told me we're out of time. I know the judges have to get back on the bench. Maria, you just want to close out on thank. We'll have to take the questions, and I'm sure each of the judges will able to respond back. Is that fine? Judges, in the interest of time, can you respond back to those questions?
Can I add, there was one question in particular from a student, a Medgar Evers College student, who just briefly wanted to know how you got there educationally, what from college, what you had to do next.
Sure.
Mr. Samuel, please. Thank you.
So for me, in the United States, there are two ways you can become a judge. First, you have to be an attorney, usually. And in New York State, so I graduated high school. From high school, I went to college. That's usually around 4 years if you go full time. After college, you go usually to law school. You go full-time is 3 years. You can also go part-time and be a little bit more. And then after law school, you go and become an attorney. And to become a judge in New York State, at least, in civil court and in Supreme Court, you have to be an attorney in good standing for 10 years. To become a judge in the housing court, you have to be an attorney in good standing for 5 years.
Great. Dr. Datta, I know we went over the time. I see the other panelists. I want to conclude by thanking each and every one of you for taking the time from the bench. I know, Dr. Datta, they didn't have lunch yet. They just came straight from hearing cases to make sure that we